our event, Public Defense and Public Defenders in Latin America and United States. This is a partnership between the Indigent Defense Research Association that is hosting this online event, but also Rutgers University, Federal University of Minas Gerais, University of California at Irvine, and Autonomous University of Barcelona. My name is Ludmila Ribeiro, and I am a professor in the Department of Sociology and a researcher at the Center for Crime and Public Safety Studies, both at the Federal University of Minas Gerais. I am going to say just a few words in order to start our event, and so we can hear from our specialists and the people that we have invited to share their knowledge today. So we have today we have experts from all over Latin America and the United States that have dedicated their careers to not only do research about the criminal justice and access to justice, but also to the improvement of indigent defense system. So let me take only a couple minutes to explain to you all how we have arrived here. Last April, we were invited by the Indigent Defense Research Association to present an overview of the institutional features of the legal defense organizations created in Latin America in the last decades, and to discuss their main achievements and setbacks when put in motion by the indigent citizens. At the time, we highlighted how indigent defense has been a long-standing issue for us, at least for Brazil, Chile, Argentina, and Colombia and Mexico. Efforts to create legal defense institutions are recent in these countries, and there are many different defense systems in place in the region. And when we started to share the lessons that we have learned during our research, we were very impressed to realize that some of these challenges are the same in the US. And issues varies from institutional design of these organizations and the experience that citizens report when assessing justice, and the fact that comparative data is scarce and sometimes unavailable, making case studies the only option for us in order to gather information regarding how the legal defense is provided. So from this panel that was organized last year, we were invited by our colleague Andrew to organize a second panel, and it ended up with a seminar because Gustavo, Andres, and Miguel and we thought that it might be a very important moment to understand how United States and Latin America share many significant issues related to this disjunction between formal rights and the actual realization of these rights. So we got together and tried to organize the seminar in order to highlight especially how we measure the quality of legal representation. So we are here today in order to understand a little bit more about the service offered by public defenses, especially in terms of how effective is access to justice system by the indigent citizens. Our main aim is to contribute to the understanding of how these agencies are set in motion the challenge that they face in effectively salvaguarding the rights of indigent individuals. And this is why we decided to invite so many colleagues from all over the Americas. We would like also to emphasize that our aim is not to host one-time seminar. we have as a main objective to gather input from our presenters and from the audience about what steps we can take in order to make this subject stronger in the academic field. But we are also committed to establishing a network of expert researchers focusing on public defense and how to improve the services delivered by these agencies. So please, when closing up your remarks, we would be very grateful if you could include some ideas for comparative research and advocacy in order to make public defense institutions stronger in Americas. For us, this is a very special forum, and we would like to make our best to at least have a plan regarding how to move forward from today to other meetings and to other publications. And maybe we could even plan a face-to-face seminar. Regarding the logistical issues, I want to stress that each presenter will have 12 minutes to introduce their main ideas. Our moderators will help to manage the time, and we'll let you know when there are only 3 minutes remaining. And we know that it's very hard to say everything that we would like to in only 12 minutes, but for us, it's essential to respect this time limit to ensure that we'll have at least time for discussion about some comparative research and next steps that we could take as a group. So I'm going to introduce our moderator, which is my dear colleague, Miguel Quintana-Navarrete, who is a professor at the Department of Criminology, Law and Society at the University of California, Irvine. He has earned his PhD in sociology from Harvard University with a dissertation about the consequences of violence and criminal justice involvement in Latin America and Africa. He has also a master in criminology and critical justice from King's College and a BA from the Universidade Sonora in Mexico. He has a very extensive research and has contributed significantly to legal studies in Latin America. So, Miguel, it's up to you.
Oh, thank you, Ludmila, for that very kind introduction. I wasn't expecting that, so thank you very much. Yeah, so I'm the moderator for the first panel. And yeah, as Ludmila said, we have, we're a bit pressed for time, so we're going to be, each panelist is going to be speaking for about 10 to 12 minutes, and then at the end, we're going to hold one single Q&A section for about 10 to 15 minutes. So I ask, if you have any questions, you can either hold them to the end or put them in the chat, and I'll get to them towards the end. And yeah, that's it. So I'll introduce the great panelists in our first panel. First, we have Ricardo Lillo, who is an assistant professor at the Universidade Adolfo Ibáñez, sorry. Ricardo holds a SJD from the University of California in Los Angeles. We also have Maria-Fátima Santos. Maria-Fátima is a PhD candidate in the Department of Sociology at the University of California, Berkeley. Then we also have Pablo Ciocchini, who I'm not sure if Pablo is here yet, but I'm still going to introduce him. Hopefully he'll make it. Pablo is affiliated with the Department of Sociology, Social Policy, and Criminology at the University of Liverpool. And Pablo holds a PhD in Sociology of Law from the University of the Basque Country. And last, but certainly not least, we have Andrew Davies, who is Director of Research at the Decent Criminal Justice Reform Center at SMU Dedman School of Law. And Andrew holds a PhD from the University at Albany School of Criminal Justice. And he's also one of the main organizers, and you heard him speak earlier today. So without further ado, Ricardo, can you start us off?
Sure, thank you so much, Miguel. Just I will share my screen. But in the meanwhile, I just would like to say thank you so much for organizing this event and for having me here. It's such a pleasure to be part of this. So thank you so much. I don't have the sharing screen feature available. Can you please do it for me?
It should be fixed now if you try again.
Thank you. There you go.
Perfect.
Okay, can you see my presentation, right?
Looks great.
Perfectly.
Okay, thank you so much. Just let me. Okay, well, this presentation for today, for this event, is part of a large, long delayed project that I have been working on, which is focused on how to measure the quality of justice more broadly. The idea is how to produce indicators that provide us information, like from a comparative perspective, right, on how good or how on the quality of justice. Basically, that's the idea. And for this presentation, I prepared something about our public defense system, focus on the criminal justice system. Perhaps I will say, if there is time, about our civil justice defense system, which is completely different, as I will try to explain in this short 12 minutes presentation. But let me provide you first with some context information. I think it's important to understand this project. Well, in Chile began, as many other Latin American countries and other from abroad as well, quite deep criminal justice reform in the last 20 years. It's being described as a quite a deep reform process because we replaced all our quite pure old inquisitorial system. And I said this because it was a system where the judge was completely in charge of prosecution, that we didn't have any type of public prosecutor office and that kind of institutions, and where it was a criminal procedure where the opportunities for the defense to effectively protect the rights of the accused, it was quite limited under the old criminal procedure. So we had to create new institutions from scratch. We created a public prosecutor office, and also we created a public defender's office, basically because the system of legal representation, of legal aid that we had under the previous system, it wasn't simply enough for an adversarial type of criminal procedure. So we create both institutions from scratch, and I think it's important to understand this. And how it's organized, basically, we have a public defender office at national level, and we also have local offices, one per region of the country. We're a small country in terms of population. We are 15 or 16 million people inhabitants. So I will show you some numbers to understand the magnitude and the jurisdiction of this public prosecutor office. But it's focused only in criminal matters, and I think that's important as well because it's different than many other Latin American public defense systems. The service, the legal representation by the public defender office, is provided by two types, basically, of public defenders. The public defense office has permanent staff lawyers, which comprises about 1/3 of the defenders, and the other 2/3 of the defenders are they are private lawyers. They are lawyers who participate in a public tender system, and so they are paid by the service they provide to the institution. But both are legally considered as public defenders. Okay. And who are the beneficiaries of the system are basically every accused or person being subject to prosecution, basically, from the initial stage of the criminal procedure until the very end. even in the execution phase of the decisions. But it's for every person who is accused or prosecuted against. This is a constitutional right provided by the Chilean Constitution, and it's a non-waivable right. So this is a free public service, which it will be for every adult, basically, and people under the juvenile justice system as well. So it will be a free legal representation for every criminal defendant, unless the defendant is considered, one, an adult, and secondly, if he or she has the means to hire a lawyer. In those cases, we will have to pay for the public defender service, and they will pay under an economic assessment by the institution, which include the earnings of the individual, his or her payment capacity, and how many dependent has in his or her household. And the system provides a mandatory previous information on the rates and everything. The system provides general defense for every kind of criminal murder, and as well it provides specialized units for several groups of vulnerable people, prison population, juvenile justice, indigenous population, and the others that you can see here in my screen. One of the main critics about these special units is the lack of empirical research on specialized defense, with some notable exceptions. For example, the work done by Carbacho, Valdez, and Mateo, and Carbacho in many other articles, who focus on prison population legal representation. In terms of the numbers of the system, the Public Defense Office had, for example, in 2022, about 300,000 cases filed, which represent around the 15% of cases which are filed in the justice, in the judiciary, basically. In my database that I will show, about 80% of the accused are represented by public defender office, by public defenders. In terms of who are the beneficiaries of the system, they were mainly adult men of Chilean nationality, not identified as part of our indigenous population. And you can see the numbers here, and I can show you later if you want, like the specifics for each vulnerable group. The Public Defender's Office in numbers has a annual budget about $72 million, and a staff of permanent attorneys around 200, and 524 lawyers who are hired in this public tender system that I told you about, and they provide both the general criminal defense and the specialized defense as well, which means like a ratio about 370 cases per defender annually. Now, let me go to this straight, how to measure quality. Of course, there are many ways and many conceptions on what a quality criminal justice system is. We can focus on user perception, kind of subjective procedural justice approach, or we can focus on the quality of the final decision and how, in terms of correction, for example, or in terms of how good it is for the interest of those who are subject to the judicial system. Or you can focus on specific procedural stages where the system is designed to provide some supervision or control in terms of trying to, at the end of the criminal procedure, to have a better outcome, basically. And I will say my database and my focus is on the latter, but there are some information as well on, for example, on user perception that is published by the Public Defender's Office. The database that I have been using for this presentation is based on a work done by Gustavo Fondevila It's called the Latin American Criminal Justice Dossier Project, and I was in charge basically of the Chilean chapter. Basically, I was in charge of providing the database. It was a quite extensive work of about 2 or 3 years collecting data, and I can tell you more about in the Q&A later if you want. We'll be more than happy. And the other information that I'm using is publicly available on the Public Defense Office website. In terms of user satisfaction, in fact, it is quite high. I just have 2 graphs on this, which I collected from the Public Defender's Office external audit on user satisfaction, which is from 2021. They do it about each 2 or 3 years, this kind of measures. And the level of satisfaction in terms, it usually quite high. The grades are between 6 and 7. And for those who are not aware of our grading system, 6 and 7 are the highest grades. And the percentage of people who is unsatisfied is around 20%. Those topics where there are more critics regarding the service is regarding the communication between the accused and his or her public defender. Not in terms necessarily on the quality of the interviews, more than on the frequency of these kind of interviews between the accused and the defender. And regarding I just want to show you some data that I have, and then we can discuss on how to use it. It will be great to have your inputs on this. But just as to show you, it is a database who comprises more than 1,300 cases collected from both type of criminal first instant criminal courts in Chile, which are the courts of guarantees and the trial courts. It was, of course, a certified random selection of disposed criminal cases. And it provides a lot of type of information. In terms of the kind of data that we have, I'm sorry, this is in Spanish, but I can translate. For example, we collected information on if there was a replacement on the lawyers that were initially assigned or hired by the accused, and is the proportion of cases where there was changes between defenders is quite high, and that explains by how it works. The public defense system is not a single defender for each case. It's not one case per defender. In the single case, there are many hearings, and many public defenders might attend that specific hearing. The other type of information that we have is, for example, on the first appearances, or how we call it, it's like the hearing where the detention is supervised and it's decided if it's legal or illegal. 98% of these detentions are considered as legal by the judges. Only a small amount of them are declared illegal. And the type of information or the variables that are controlled by the court range between duration, the mode of the detention, the place where the people was detained, the enforcement agency involved, and so on. The point is, from the point of view of the quality of the public defense system, is these controls, or these variables that are controlled, are only in about 11% by party request, which is quite low. And in fact, there are other research on the other reports in the Chilean literature that are quite similar to these findings. In terms of other control variables, and I'm about to finish, so because I know that I'm on time. The type of information that we have, for example, at pre-trial stage, we have information on if the public defenders versus private defenders, if they appeal, if they requested for a pre-trial detention revision, if they requested for an early dismissal, if they requested for the exclusion of evidence, if they incorporated evidence to the criminal procedure. appeal for court decisions, or if they question decisions by the public prosecutor office. In terms of the trial, basically, we have information, for example, on the type of evidence that each type of lawyer or of defense provided. For example, we have information on witnesses. We do know that most of the witnesses that the final decisions are relied on are mostly incorporated by the prosecution. Just a small percentage of those witnesses were filed or presented by the defense side. I interviewed one public defender for another project about this specific variable, and he told me that it is about the public defenders, because of the lack of resources, they tend to rely on the proof that is presented by the public prosecutor. The same, for example, with expert witnesses. It's much frequent that the defender goes to cross-examine or to attack the evidence that is presented by the public prosecution than present their own expert witnesses, for example. And the possible explanation here is the lack of resources of the public defender's offices. Finally, we have information on who appealed the final decisions. Most of them are, of course, the public defense, and we do have information on the type of the defenders that appeal the final decisions. So this is all for now. I have a lot of information. This is a huge database. Of course, we can go deeper if you want in the Q&A section, but thank you so much for inviting me and for letting me share these thoughts. So thank you so much again.
Perfect. Thank you, Ricardo. Maria-Fátima?
Perfect, thank you. So I'd like to share my screen. Just a quick question, does it share all of the screen, or can I just select part of it? I'm gonna click this and see what happens. Okay, here we go. Sorry, 1 second. Okay, I'm going to. There we go. Can you all see my screen okay?
Perfect.
Yes.
Okay, perfect. Okay, so thank you for this wonderful invitation. It's very excited to join all of you. And so today I'm going to present on some of my dissertation fieldwork. This is part of a larger dissertation and book project that studies the social trajectories, motivations, and everyday work practices of public defenders who work in the penal courts of 2 Brazilian cities. And one is Salvador in Bahia, and the other is São Paulo, which is, I'm going to share some of those findings with you today. Before I start, I should give a very big disclaimer of the very big sins I'm about to commit, especially for an audience of legal practitioners, which is, given the limits of time, I'm actually not going to go into the particularities of the organizational structure or legal structure of Brazilian law and legal aid, precisely because during this time, I'd like to basically kind of provoke a potentially different way of us conceptualizing what legal aid work is that might be able to help us ask questions in a different way, to also think methodologically about how we tackle legal aid work in different social contexts. So these are my sins. Please forgive them. If you'd like specifics about the particularities of Brazilian law, I'm happy to answer that in the Q&A. So first of all, let's start from the fact that we all know that the law is far from autonomous or neutral. In addition to the very content of the law itself and the types of crimes and how they're defined, we also know from lots of previous research that from the start, the police selectively enforce penal laws. And they do this in ways that have played a fundamental role in producing inequalities along economic lines, ethno-racial lines, gendered lines, among many other forms of social division that produce inequality in different ways in different societies, right? But court actors play a fundamental role in evaluating police work once someone has been arrested and detained, and in evaluating the people and behaviors, right? And so my question today is, how do legal aid professionals actually influence court processes? And to do this, I'm going to actually suggest that we kind of push beyond a framework that talks about more or less effective legal counsel, right? All practitioners, public defenders, legal aid professionals of all different types know that, you know, the law is far from objective and neutral. And so thinking about more and less effective legal counsel also leaves you in this conflict where you understand, wow, I can help my client, but at the same time, there's something I'm also legitimizing on some level too. And so how can we maybe reconceptualize in a way that's helpful to tackle that head on, right? So the way I am going to understand the role of court actors in general to get to what legal aid work does is to understand that what court actors fundamentally do is that they orient and they legitimize how states exercise coercion, right, through their penal power, right? And I'm building on a lot of previous research, and just bear with me because we're going to get to where legal aid comes in. First of all, previous research shows that in order to legitimize and orient state coercion, states develop a criminalized object of coercion, right? We're talking about defining crimes and defining behaviors. There's also a particular mode of coercion that's defined, right? We have, particular kinds of punishments that are acceptable in relation to particular types of people and behaviors, right? The law fundamentally writes this out in very beautiful and quote unquote rationalized language. And this actually plays a really key role in legitimizing that states are actually able to routinely exercise punishment every day, right? But as practitioners and many scholars know, how this is constructed on the day-to-day is not how it's constructed on paper, right? Instead, this depends on the formal rules of law, but it also depends on the everyday workings of court processes and everything that goes into that, right? From different legal cultures and racialized logics, different state capacities, right? Lots of things that previous literature have shown us, all of this goes into how these two components are defined and the relationship to each other, right? And then most fundamentally for today, this means it fundamentally depends on everyday court actors. How they understand their work, their relationships to other court actors, and all of these different dynamics come together to really shape the outcome of who fundamentally becomes named an object, a legitimate object of state violence, right? And by what means, right? To do this, though, this isn't an objective process, as I've just talked about. Rather, what I, conceptualize, and I'm happy to talk about this more later, is that this is basically a struggle between court actors within an interpretive terrain. At its heart, what court actors are doing is that they're struggling over how to interpret people and behaviors in relation to written law. And every court actor has a different position. They have different professional interests, different training, right? And this all goes into that output, right? So this is sort of like, well, okay, lots of things could affect things. So what becomes useful analytically is actually studying legal aid professionals and asking, well, what are the different ways they can intervene in this terrain, right? By intervening in who and how criminalized objects of coercion understood, and what is considered acceptable punishment, legal aid professionals are able to challenge or mediate or avoid that certain clients face certain levels of coercion, right? But at the same time, they are nonetheless legitimizing a system that is going to exercise coercion towards other people and to different degrees, right? So it's a way to account for that, kind of Janus-faced function that many practitioners already understand, probably even more than researchers, right? The contradictions of your everyday work. So to really get at, well, how do we identify the factors that matter in a particular context? I'm identifying 3 strategies that legal aid professionals employ. And the question is, when, how, and why do they exercise each of them? And answering that question can help us figure out, well, what matters in this particular social context and court context, right? One is that they instigate doubt about how other court actors are interpreting their client, right? They're instigating doubt about the interpretation of their guilt or what they're guilty of, right? They're also actively harnessing resources to contest how other court actors are interpreting their client, right? So that's when, they're able to get witnesses or documentation to actively contest with an alternative explanation of what happened, right? And then there's negotiating an alignment, right? And at its heart, I really want to emphasize this is about interpretation. Legal aid professionals are basically negotiating with, let's say, for example, prosecutors and judges. How should my client be interpreted, right? And at the end of the day, there are different interests and different points of view that are being, negotiated to come to this, alignment. So what I'm going to do very quickly and really brushing over this is, from São Paulo, I'm specifically going to focus on cases that have to do with people facing prosecution for drug trafficking, and in São Paulo in particular. Right, the illicit drug commerce in Brazil and in São Paulo in particular is highly lucrative. Politicians have, employed tough on crime policing practices, but they don't target the main operators or benefactors of these very illicit markets, as previous research has shown. Instead, they're primarily targeting poor and disproportionately preto and pardo people, so Black and brown people in Brazil and in São Paulo. Okay, I'm going to skip over this. Basically, the public defenders I'm focusing on today are those that are working within the Barra Funda criminal complex in São Paulo, which is the largest criminal courthouse in all of Latin America. And public defenders work world, for those who work in the post-indictment courts that I'm going to focus on very quickly, they are basically working in between being in the courtroom in their offices they have trials every day, and they also are then working in their offices doing paperwork and that sort of thing. And the question is, well, what is it that they're actually trying to do? Just to brush over this for the sake of time, they try to instigate doubt about their client's guilt. One of the main challenges that they have with that is that there's a profound legal culture that presumes the guilt of their client, right? The other challenge they face that's related is that there's a lot of honor and respect attributed to police work by judges and prosecutors, right? And so as one public defender said, so it's not a question of analyzing who has presented a more plausible or truthful version. From the moment the witness contradicts what the police is saying, they may already be treated like they're committing perjury. This happens in a lot of courtrooms. So in addition to presuming the innocence and guilt of clients, right, even when legal aid professionals are able to bring witnesses forward to speak on behalf of their client, there's a tremendous amount of honor and respect attributed to police officers that makes it so that, witnesses might even be penalized for participating in this process, right? Contestation, there are many difficulties to contestation. This really goes to resource constraints for São Paulo's public defenders, which I think many other contexts can speak to, right? There's very little time, very few resources to actually go after some of the potential leads to the interests of your client. And then potential witnesses are also afraid to come forward, right? They're afraid of the state itself, and they're afraid of the commandos that organize their communities. But there are opportunities to contest by appealing to higher courts. I'm going to pass this just for the sake of time, but basically there's a lot of negotiating interpretive alignment in different São Paulo courts, precisely because of the difference between how judges at the local level and higher courts of appeal interpret Brazil's drug law. And this makes it so that public defenders, oftentimes if the judge has too punitive of a sentence relative to a higher court, they can appeal to a higher court. But there's also cases where there might be risks to that. So in some cases, they might produce an informal negotiation with a judge or with the prosecutor, depending on their position. What happens is basically through these different dynamics in different courtrooms, there's different court routines and processes, even in the courtroom next to them, right? But public defenders, through their strategies and their individual successes, are actually able to contribute to that routine, right? And to talk about the implications of this, right, really quickly, I know I'm going quickly. The implications of this, and we can get into this Q&A, is thinking beyond effective legal counsel. We're really able to lean into the fact that legal aid professionals have this Janus-based function, right? They can challenge it, penal force to their clients in particular ways, but they also, legitimize the system. And then also law is selective, it's routinized, and it's also arbitrary, right? We know law is selective, we talked about that. Public defenders contribute to routinizing it, but the routines that take place in different courtrooms show that at the same time, all of these forces can become arbitrary. And that actually undermines the very story politically that legitimizes the state's ability to exercise violence, which is that the law is routinized and rationalized and therefore not arbitrary. Thank you. I'm going to stop there, and I'm happy to answer any questions in the Q&A.
Great, thank you, Maria-Fátima. Thank you very much. Pablo is here. Pablo, are you ready?
Yeah, yes, hey, I'm here.
Perfect. Perfect.
Hi, Miguel.
Okay, go on.
Okay, well, thank you. I'm very sorry it took me so long to get, but we will have another activity, and we were like I will just share the screen. I will find the file. You should just give me a second. How do I do it? Sorry. Public defenders here. I'm not sharing, no, right? Not yet.
Not yet, no.
Sorry. Well, now.
There you go.
Is it working?
Yeah.
Okay.
Yeah, it is.
Okay, so I'm sorry. So my name is Paulo Ciocchini, and what I'm going to present today is part of research project that we are conducting with Ezequiel Kostenbein. Went from La Plata, Argentina, in the province of Buenos Aires. So what we want to talk is a bit about how public defenders see themselves, how do they understand the job, but even going beyond that, how do they construct their own subjectivity as public defenders? And that is related to the kind of different commitments they have with different actors and elements. So just to say that we were talking about province of Buenos Aires, which in terms of Argentina is very important because it's 40% of the population is living there. When we see the figures about the number of investigations, criminal investigations, and cases, we realize that it's a huge, it's significant in terms of Argentina, but also in terms of the region. Not that there are no other jurisdictions that are bigger, but it's one of these jurisdictions which is pretty massive. And another important element is that it's big. The big majority of the people are being represented by public defenders. If we go to the people who already are detained in prisons, this is almost all of them, 94%. When we look at the cases, that goes around 89 to 90. So it's clear that what the public defense is doing is actually shaping the way that we understand how defendants are being represented in criminal cases. What I'm going to, the results I'm going to offer to present today is part of a small research project that I started, like an exploratory research project of like interviewing 10 public defendants, but we've been working for more than 10 years. So we have behind ourselves like hundreds of interviews in different projects connected that have been shaping the kind of questions we are asking and how we understand this. And we are innovating with, at least for me, is innovation using this theoretical framework of pragmatism, sociology of pragmatism that we're using Bernard Lahire and Laurent Tenebon. They have this way of understanding the kind of like the plurality of commitments and plurality that one individual has, and how those kind of like folds into constructing a particular way of understanding reality, and that kind of understanding, that interpretation of the external reality is being interiorized and socialized. So this helped us trying to move beyond what is the official role of public defenders, moving even beyond what is kind of like legal strategies they deploy, and trying to understand a bit more about how they feel about it. So it's not just about the Russians, but also the emotions that mobilize their work. Again, for context, what happened in the province of Buenos Aires is something similar of the trend that has covered the whole Latin America, but also other regions. There was a replacement of criminal procedure codes, and countries like Argentina, the criminal procedure code is significant in terms of how organized and reorganized the way that the dynamics of the courts and the different actors. We have now a more kind of adversarial based system, and this is significant because it has reconstruct this idea of two parties, the defendant and the accusation by the prosecutor, and how there's a tension, and that creates this idea of some kind of like struggle to find justice that it was in the previous system much more subsumed in the idea of a collaboration of different professionals into reconstructing what had happened and what will be the best way of responding to that. So there's a replacement with adversarial. There's also introduction of plea bargaining, as we know, which is adaptation. Maximo Langer talks about this, the differences in different adaptations, but and it's a significant difference from the plea bargaining of other jurisdictions, but still the kind of like logic is the same, and is that a system that is based on adversarial criminal trial cannot cope with dealing with all these cases, so it needs to have some kind of alternative that basically offers the possibility to avoid all the hassle and find a solution before. And then the reform itself was considered to be, or perceived to be by the legal professionals themselves, a failure, because it didn't change significantly the practice until between 2004 and 2007. But starting 2004, there was a new reform, a reform that started by just introducing some kind of like suggestions about simplified procedures for cases in which the defendant was caught red-handed. But then there was a whole process, internal process of reforms, but based on kind of like motivating and the very legal professionals to think themselves of how they can change their own practices in order to achieve certain institutional objectives. And that ends up by introducing hearings before the trial, open hearings where people are supposed to discuss alternatives and solutions, and that in a context of a much less formalized process, specifically for cases in which there is not much discussion about the facts of the case, because the individual was already the kind of like the very testimony of the police, who the defendant is key in order to be able to sentence them. So it's in this context that we will try to understand the public defender's identity. We know that there's this constant tension with public defenders between who they are working for, state, society, itself, or defendant, and this is even more messy in the province of Buenos Aires, because the Public Defense Office is part of the bigger, larger organization, which also includes the public prosecutors. And so they are inside the same organization, and the law itself defines the official objectives or goals of the institution as to act in the interest of the defense of society. So some has been an interpretation of that in terms of like still is okay, 2 minutes. Okay, well, let's jump. So the point here is that there was the adversarial system changed significantly the role of the defense, but at the same time, the institutional design still kept them in a kind of like subaltern position. So we explore interviews trying to understand how they experience these changes and how they see themselves. And I'm going just to name some of them because I don't have too much time. But basically, we found is that there is a clear identification with the institution in the way that they talk about themselves as they talk about institution, and that shows that a level of commitment with the institution itself that is significant. And then there is all these kind of tensions with public prosecutors that they share spaces, they share the same social spaces, they same, in many cases they share the same background, but still because of the adversarial system, they tend to construct it different, and they tend to interpret what the prosecutors are in kind of like a more ideological way. That kind of creates a distance, and so they look at them as tough on crime, and then themselves to be what we call garantistas, basically ensuring the fundamental right, the protection of fundamental rights. But they do have also preventive commitments, not only with the defendant, but the family of the detainee, with the context, social vulnerability context in which they are, and the prison conditions. And that creates them, although they are all related, they are not the same type of commitment. And that creates sometimes contradictions and tensions between what is best or what do they believe they have to do for the family and what do they have to do for their own defendant, and how they see themselves with in recognition of the prison conditions. How do they present themselves? They see many times as kind of social workers. They ensure trying to offer some level of access to benefits and public and welfare to the family, not even to the defendant. That goes beyond what we'll say the strategy of defense of the case, of criminal case. But also, and then I'm just going very fast, but I'll open then later for questions. That kind of like image of them almost kind of romanticizing the defendant and the commitment with the social conflict, and that is the background of the case they are dealing with. Also has to say in the practice there is some kind of dissonance because at the same time they are pretty much pro-plea bargaining, although they know the problems in terms of the illegality of many of the police procedures, or they know that it's basically surrendering to a better defense, and they still, but at the same time, the institutional pressure, the pressure themselves, this commitment they have with the institution that make them surrender and accept this. So in this very, very, very short to finish here, what we found interesting is how these different and contradictory commitments shape the way they are. But this, despite there are differences in the individuals, we do see a pattern of kind of certain way of constructing what is to be a public defender, what kind of like attitude have, that has some kind of like ideological perspective, and which doesn't inform necessarily all the practices, quite the opposite, but inform the way the narrative that justify what is the position they have. And how these also see themselves always borderline between social workers and legal professionals, and they kind of like are open to this kind of a space, and they try to do some kind of connections that is not institutionalized, but it is a practice, a common practice. And with this, I'm going to finish us here. Thank you.
Thank you very much, Pablo. That's great. Thank you. So finally, we have Andrew. I believe you're muted, Andrew.
Thank you, Miguel. I was actually thanking you while I was muted, but thank you again. My name is Andy Davies, Director of Research at the Deason Center and also the President of IDRA. I wanted to take this opportunity, recognizing that we're coming together to share and connect our work, to try and summarize the work done by Indigent defense researchers in the United States. This will, of course, be a necessarily rather brief and high-level overview, and I apologize in advance to people who I miss. But it was nevertheless quite an exciting opportunity to try and think about the state of the literature, especially at a meeting like this, when I can be forgiven for just looking completely inwardly at what we are all interested in and trying to assemble it into a coherent whole. One thing I actually want to make this into really is an argument for a certain kind of inclusiveness around what we call indigent defense research. And I'm going to rely on the archive that is in the IDRA website, indigentdefenseresearch.org. What we do here every month is we provide a list of notable recent publications in the field. We've been doing it every month for about the last 4 years. And it was by reviewing this list that I was able to come up with the summary that I want to share with you next. The criteria for inclusion on this list are relatively broad. We say that anything that exists at the intersection of data and research in indigent defense is viable for inclusion on the list of what we consider research and data in indigent defense. That doesn't exclude very much. It does, of course, include formal academic research published in journals. It also includes annual reports and statistics that defender agencies in the United States might routinely produce. It also includes anything that an advocacy group might have prepared on the subject of indigent defense, on the assumption that at some point it includes data or research in it, which very often, of course, it does. So by defining indigent defense research as any place research and data and indigent defense coexist, you end up with this particular set of work. And I think you'll see that when I try and summarize it here, that breadth of definition is reflected in the findings. I will issue a couple of caveats. What I'm about to show you is a mind map. A lot of it is handwritten. I wish I had the technology and expertise to make this into something more formal. Please forgive what are the obvious inadequacies of this presentation. I hope that nevertheless you'll be able to get the gist of where I'm going with this, and also recognize that this is my impression of the literature. This could probably be done more systematically with coding checks and so on. That is not what has happened here. I'm just telling you my opinions. So nevertheless, with all those caveats issued, I think this is really, really interesting. These are some of the thoughts that I have about this literature. There are various agendas in it. There are various authors and various voices in it, and data show up many places and have many uses. And I want to return to these themes at the very end when we think, following Ludmila's instruction about what the implications are for going forward and cross-disciplinary work and so forth. So here's where I started. There's a lot of research and data that defender systems in the United States anyway generate simply by existing. It's quite common for defenders and systems to have an annual report where they're producing data on their own operations. These reports, and you may or may not be able to read all these things. This is my handwriting, and I apologize. But what they're doing is regular monitoring and assessment of what of their function, and so as a consequence, data are often seen as necessary and are produced as a sort of byproduct of that routine work. What all defender operations are also having to do at some point is decide how to deliver services. And so defender systems come in various forms. Defender systems also engage in innovation and experiments at times. Those things result very often in evaluation, ongoing assessment, and implicitly research or research opportunities in the production of data. In addition, what we see are there are also groups in the defense and data world who are thinking very deliberately about theories of change and about system improvement. And so another area where you see people in this field deploying data is the place where people are thinking not just about evaluating policy options, but actually on how to accomplish and implement a policy change. There are systematic studies of those and people who are systematically trying to gather data on those things. So these are the kinds of things that defender systems generate in terms of data and research simply by existing. Like no academic had to intervene for these things to happen. They are just existing already. In the bigger picture is usually where academics start to step in a little bit, because academics, but also policy advocates, are very interested in the things that impinge upon defender systems and sort of can have a governing effect on the way that they operate. Lots of people interested in resource issues in the United States. This is the question about whether you don't have enough funding, you got too little staff, too many cases. This is just a central, probably the biggest theme, certainly of all advocacy literature, and is an emerging theme in research literature where people are trying to tackle the issue of caseload and its impact on the work that defenders do, or the work that defender systems do, as the way it's represented here. Also, lots of questions and concerns from both the research and advocacy community about governance. We heard a bit of this today. As legal structures around defenders change, how does their work change? How do the things that they're doing actually have to change? There's a particular concern in the United States very often about independence and oversight of defender systems. Not very much research on that, actually, but some interesting emerging stuff coming up. Also, some very good work recently about history, and we've heard some of that today also. But some I don't particularly intend to point to anybody's work in particular today, but certainly Sarah Mayhew's book in 2020 about the history of public defense in the United States is a really major milestone in that one. Also, Felice Batlin's work about, particularly in light of the group here today that was referenced earlier about gender in the early development of defender system in the United States, also really good, indispensable historical works, often concerned with things like the embedded racism of the systems that that gave rise to the public defender systems that we have today. And so these are things that researchers are usually interested in. These are not naturally occurring pieces of data and research that defender systems simply do themselves. A couple of, in my survey, a couple of emerging areas I think that were worth highlighting, because in looking at the literature in this way, the fun thing is to think about the dynamism of the field also. So one thing that I think people haven't paid much attention to, but that I'm very preoccupied with, is the accessibility of the defender system. There is, at least in the United States and at least in West Texas, there are places where there is no functioning indigent defense system and nobody gets a lawyer free of charge, notwithstanding the fact that we're 60 years after the Gideon decision. I'll get off my soapbox. But anyway, there are lots of reasons why defender systems are made inaccessible. And so no matter how well they function, some people can never get that service. That's what our work, this is the last time I'll highlight our work, but over on the right there, you can connect to our report at my center, Getting Gideon Right, which is all about the financial eligibility assessments that defender systems do that functionally deny services to criminal defendants that are entitled to it. Also, lots of work on, well, a bit of emerging work on this issue of independence. Actually, I wanted to highlight this because some of the best work I've seen about the independence of defense systems is done by Latinx authors. Particularly, I'm thinking about Professor Butu. I'm not sure I'm pronouncing that correctly, but he did an evaluation, a study of, I think, 15 different regional defenders across Brazil and looking at the different ways that their governance was constructed. Not much work in the United States on independence. And so this is one of the areas where I think we could learn from one another. Also, I was going to make a comment here about how economists are coming in and bringing more refined methods, because the one recent study on independence in the United States was done by economists and is very good. Anyway, represents an interesting story. I won't go into it further. Having said that's the big picture that researchers are interested in the review of literature, there is even more going on. There's a lot of thought about what is this all intended to do? How should we measure outcomes that the system is generating? If you look at the outcomes people study, it's very often leniency at disposition. It's very often increased liberty at bail hearings, things like that, often residing in case outcomes. But there is also separately a literature in the United States debating which outcome we should study. And there's some quite thoughtful work done by various organizations on exactly how you actually measure public defender quality, something that was already referenced earlier also. So that's in the literature here. And let's see if I can keep this moving. I've got just a couple more things to go. Then the other thing that you see in the literature, zooming still out further, is that there is an interest in external influences on defender systems. So what we have seen recently in particular is work about body-worn cameras and video evidence and how that is impinging on defender systems and their ability to do their work. There are external factors that the systems themselves can't control that are changing the context in which they work. And so that's why I'm continuing to zoom out in this way. There's lots of other work around external influences on defender systems. There's a massive amount of work about COVID right now and that impact on defender systems. And I've also put researchers down there because there is actually work considering how researchers themselves impinge on the way defender systems operate. Researchers often want to change the ways that defenders systems operate by the work that they're doing. I certainly do. But the question of how that relationship actually operates is studied and is complicated. And then the one thing that's missing from all of this that really resides at the heart of the system are studies of actors. And we also have in our country lots of studies, particularly of clients and attorneys in defender systems. These kinds of studies, because they're focusing on individuals, and we've heard a bit of reference to this already today, are quite interested in how people see their role sometimes as attorneys. They're also interested in things like the biases that they show and the perceptions that they have. There's an emerging literature here about recruitment and attrition, because public defenders in the United States are quitting their jobs. So there's a lot of interest in job motivation and retention on the job. And then there's also emerging literature here specifically studying clients and asking clients about their perceptions. This is something that's been done a certain amount in the United States, but is just being done more and more now to answer questions that can't be asked any other way. The question of why does a client decline to be represented by an attorney is one that I don't think you can answer without talking to clients. And researchers in this country have not been very quick to talk to clients. They don't do it very often. Some do it very well, but there's emerging work in that area, which I'm really pleased about. So this is what the whole world looks like, I think, in terms of indigent defense research in the United States. I wish it was a bit prettier, but I think it's all there. And if you use a binoculars, maybe you can read it all. That's my impression of it. And so here are the questions that I come away from Ludmila. What I see is that issues and methods are evolving. I think it's really useful in an exercise like this to notice that people are doing work on new issues and that methods are changing, things like talking to clients, things like the economists coming into the field. That's all really healthy. I think it's really important to acknowledge that data and research don't live in the academy. Don't only live in the academy. That's why I started with defender systems that generate data all the time. And that's one of the things that I think is strongest about this organization, IDRA, is that we have a lot of defender members who are practicing, who are using data in their professions. And they're sometimes the biggest experts on the field that there are. My questions for us is why are we doing all this? What is all this data and research for? As a matter of fact, that's not why are we doing all this. The question really is, what is the purpose of it? I think that when you look at research and data, you can usually find an implicit purpose behind it. If you are, for example, calculating the cost of an indigent defense system, why are you doing it? I think it's a really good question for us to ask when looking at the entire state of a field. Why is this data being generated and why are certain fields emerging and so on? That's something I think about a lot, and I don't think it's very explicit in the actual generation process of work. Who is most impacted by the research and how are they involved in the work? This is something that I have many thoughts on, but certainly I have in my work witnessed the health-giving properties of involving impacted people in the work. Sometimes, of course, the most impacted people by the work are the attorneys, and involving them as well has been very important to me. Also, what role for interdisciplinary research teams? I'm privileged to work in a law school, and I'm a trained social scientist, but I work mostly among lawyers and with lawyers. I think that's health-giving also. So that's a question that I have for the field also. That's all. I hope that I didn't leave anything out, although I'm sure I did.
Thank you, Andy. Thank you very much. That was excellent. So in the interest of time, we've decided to move along to the second panel and then have sort of a big Q&A for everyone, because we're running a little bit behind on our schedule. So Andres, do you want to take it from here?
Thank you, Miguel. Again, and feel free to take a break. This is sort of a transition at this point. We'll continue with the second set of presenters at this point. And I'm very happy to introduce my friend Maria-Adelaida Ceballos from the Justicia. Maria-Adelaida is a trained lawyer from Universidade. She has a master's in sociology from the National University in Colombia and a PhD in law from McGill University. Currently, Maria is the director of the Justicia, which is a center that studies law and society, and at a think tank in Colombia that produces knowledge for the region and for Colombia as well. So welcome, Maria-Adelaida. I will introduce each person before their presentation.
Great. Thank you for the presentation, Andres. First of all, I'm delighted to be here with you today. In Colombia, we have a deep deficit in the study of public defense and public defenders, as Andres well knows. So having the opportunity to interact with you, with colleagues from all over Latin America and the region is a strong source of inspiration, and I would even say encouragement. So thank you so much. Well, I don't have a presentation. In the few minutes I have, I want to tell you a little bit about three characteristics, let's say, qualitative characteristics of the Colombian context that I believe show well some of the dilemmas or challenges we find in Colombia when it comes to studying and even improving the services provided by public defenders. And just like Maria-Fátima Santos did in the first panel, I apologize for not describing the specific structure of public defense in Colombia, but we can return to that in the Q&A session. So I will be brief, I hope, and I trust that these ideas will promote or, I don't know, ignite a fruitful conversation among us in terms of cross-disciplinary and comparative work. Okay, so the first challenge I wanted to share with you is, I would say, a meta challenge or a meta problem, and is the lack of official data. We don't have robust official data on almost anything related to public defenders. We hardly know how many public defenders we have at a given time, but it is very difficult to find information on more than that. So we don't have any data on their academic profiles, on their backgrounds. We don't have data in terms of race or ethnicity, on their workloads. I mean, we do have access in terms of the general workload for public defenders, but not for each individual. We don't know for how long they have been public defenders, the type of legal work they undertake, in addition to being public defenders, because they also can have like their private offices. Sometimes we don't even know what areas of law they have specialized in. I mean, the situation is so extreme that I have tried to collect information on the disciplinary sanctions they have received, and we do get like the number or the person who has received the sanction, but not the type of action or the fault that they committed. So as you can imagine, these circumstances entail really like huge limitations for empirical researchers, because we have to start our research projects from scratch, basically. So that is like the panoramic view that I wanted to share with you as a meta challenge, like I mentioned before. So having said that, the second issue is directly related to the meta problem that I just described. And the second issue is the lack of regulation and control over the legal profession in Colombia. So a few years ago, I wrote a book in Colombia with Professor Mauricio García Villegas that is called Abogados sin Reglas, which is something like lawless lawyers. What we basically highlighted in that book is that in Colombia, we don't have a bar association that sort of groups or controls all legal professionals, and we don't even have official exams that control the access of the profession, the access to the profession of the new law graduates. In that book, we have a small section on public defenders, but it was, again, extremely challenging to obtain information to write that section. And we sort of concluded that the lack of regulation illuminates many of the issues that we find in terms of public defenders. So the lack of regulation partly explains why there is so little information about public defenders, because the information is not centralized, but also it explains other more substantive circumstances or phenomena of public defenders. So for instance, in many cases, contrary to what we or many people might assume, public defenders can be much better or have a higher quality than private, let's say, low-cost private attorneys. Because public defenders do have to go through a screening process, while private attorneys are not subject to any type of control or regulation in Colombia. There is a whole system for selecting public defenders, which works relatively well, I would say, to the extent that at least there's a system that checks that the defender meets certain minimum requirements. And there are also programs to sort of monitor periodically the quality of the work of public defenders, which is something that definitely does not happen with private attorneys. So I could say that the only control over private attorneys that we have in Colombia is exercised by their clients. And as you can imagine, this control is very weak, or even, I don't know, non-existent when the clients are people in vulnerable conditions. In the same line, public defenders receive periodic training and have meetings that are called barras académicas, or like academic bars, in which they discuss their cases and discuss legal strategies. This is something, again, that certainly does not exist in relation to private attorneys. Some studies have shown that these academic bars are not without problems, because they apparently focus too much on the discussion of dogmatics and like procedures, but neglect topics such as, I don't know, efficient case management, for example. But still, my perception is that those barras académicas are valuable spaces, are valuable learning spaces for public defenders that, again, we don't have in terms of private attorneys. And the third issue that I wanted to bring to the table, or the third characteristic, is the fact that Colombia is a country that has been historically affected by the armed conflict and by structural violence. And these characteristics necessarily have an impact when structuring or studying public defenders. A first example of this situation is that if you want to be a public defender, in principle, you must have a postgraduate degree in a field that is directly related to the public defender program that you're trying to join, right? Or at least you have to prove that you have experience in that field. However, due to like the territorial fragmentation we have, there are many regions in Colombia, for example, regions that are affected by the armed conflict, in which these requirements simply do not apply, because if you do apply the requirements, then you wouldn't have enough public defenders. So you have to choose whoever applies, basically. So, and I think this connects nicely with what Andrew said earlier about the concern about the accessibility of public defenders, and how you must, or we must, find sort of a balance between higher quality and accessibility in certain regions in Colombia, or in a fragmented context like Colombia. And another example of the impacts of war is that public defenders in Colombia not only represent like the defendants, but also represent the victims, basically the war victims. And although I didn't have access to data about this, it is to be expected that the number of victims in need of public defense has significantly increased after the peace agreements with the FARC guerrillas. And this, of course, brings many new challenges and new workloads or new burdens for public defenders. And these burdens, as far as I know, are yet to be studied in depth. But my bottom line is that we have to pay attention to context. And a country like Colombia has some very peculiar dynamics that I think are worth considering with special care, or with special caution and attention, and especially from an interdisciplinary approach. I think I'll leave it at that, but thank you again for allowing me to share these preliminary thoughts with you.
Thank you, Maria. That was great, and thank you for connecting your work also with what Andrew said earlier. Of course, that we planned this very well. Not really, but in a sense, of course, it kind of like stems from it. Thank you for sort of talking a lot about context and war, and obviously the profession. These are all sort of important things to think about when thinking about the work of public defense. Now I want to turn our attention to my dear friend and colleague, Valerio Baćak. Valerio is from Croatia. He has a PhD in sociology from UPenn. We're not going to hold that against him. And he has done a lot of comparative work, both qualitative, some of it quantitative, on police and on public defense. So Valerio, thank you for joining us. We're excited to have you here.
Thank you very much, Andres. Can everybody hear me? Okay, good. Well, I'm really excited to be here. Thank you for the invitation, especially for giving me extra work during the beginning of the semester. I can't say, Andres is my faculty chair, so I can't say no. No, I'm kidding. I'm really excited to be here. I'm actually reading the book by Gustavo Fondevila, who I see is here today as well, about prisons in Latin America, which made me very curious about what's happening with access to justice there as well. There's, very promising developments in the US in terms of policies, perhaps around indigent defense, and especially, as Andy said, a lot of new, really excellent studies on public defenders and indigent defense systems. I would say largely due to Andy's fearless leadership. I'm a big fan of Andy's and have been since we met 4 years ago. But also, there's still huge challenges that public defenders experience, and for reasons that go beyond individual attorneys and individual agencies. And this is what my talk today, the 10 minutes, will be about. Similar to Maria, I have no slides, and I'm very proud of that. So hopefully, it's still going to be entertaining and interesting enough. I do have some notes, so no worries. Okay, so this work that I'll talk about today is joint work that I did with my colleague Sarah Lageson from the School of Criminal Justice and Kathleen Powell, who used to be a PhD student in our program, and now she is a faculty member at Drexel University. I want to definitely give them a big shout out for the really terrific work they did on the project. And the project is a qualitative interview study with 87 public defenders from 17 states in the US and the federal system. And the general goal of the study was to understand the kinds of occupational stressors that public defenders experience and how they account for them, or how they talk about them, or how they explain them. And what was really fascinating to us is that even though we didn't ask our participants to specifically about the macro level factors that affect the types and levels of stress they experience at work, most of them consistently took the conversation we had with them in that direction. So once we had the transcripts and we had a chance to really dig deep into what people were telling us, we coined this term to explain what's happening. The term is the stress of injustice. And we defined it. I have a background in medical sociology. That's really what I do with respect to the criminal justice system. So I'm all about sociological stress research. And we define the stress of injustice as the social and psychological demands of working in a punitive system with laws and practices that target and punish those who are the most disadvantaged. It's a little bit of a lot of words there, but the idea is that the legal context, laws especially, and related institutional practices of the criminal legal system operate as structural forces that expose public defenders to distinct and high levels of work-related stress. All right, so we found there are three components of the stress of injustice. The first is punitive excess. The second is the chronic underfunding of indigent defense in the US that's been happening really for a long time. And the third component of the stress of injustice is the criminalization of mental illness and substance use disorder. Okay, so what I'll do now, I will briefly describe each of those three components, and then I'll talk a little bit about our implications of our findings, both for what's going on in the US and internationally. So punitive excess is really perhaps what many of you are familiar with. It's really what makes the US exceptional in terms of criminal punishment relative to similar countries, especially in Western Europe, but also really to many other countries across the world. And these aspects of punitive excess include things like very long prison sentences, mandatory minimums, and really thousands of collateral consequences that people who are released from incarceration experience and that are attached to their criminal record. The second component of the stress of injustice, as we define it, is the underfunding of indigent defense. And that's really a long-standing problem that's been around ever since, the Gideon decision. Public defense has never really been adequately funded, and that continues to be the case today. And some of the things that are really important when it comes to underfunding include excessively high caseloads that public defenders have, especially across the country, but especially in the southern part of the country and perhaps in states that don't have a state-level public defense office. And related to that, attorneys have very limited time to spend on any one case and client. They have limited access to critical resources, such as investigators, and really generally or relatively low salaries that prevent attorneys to continue in their careers as public defenders. And the final component of the stress of injustice, as we see it, is the criminalization of mental illness and substance use. So I was very, I guess, surprised in the first presentation when Ricardo said that about 50% of criminal cases in Chile are represented by a public defender. And I think in the US, that's at least 80%, if not more. And a lot of the clients, they have very high rates of trauma-related mental illness and substance use disorder. And instead of getting care, adequate care for those issues and having access to medical institutions, they kind of cycle through institutions of punishment instead, jails and prisons, and become really frequent clients of public defenders. And the implications of that is that the people who suffer from substance use disorders, and this is something we found in our study as well, may be less likely or are not able to stay in touch with their attorneys regularly, which makes it more challenging for the attorneys to represent them effectively. And the trauma they experienced by many clients makes public defenders really vulnerable to secondary traumatization and compassion fatigue, which eventually really makes the job that much harder. All right, so I'll skip the limitations part. So I'll just note a couple of implications of our findings in our study. So we didn't collect the data that can tell us how kind of these occupational stress for attorneys can affect clients and the ability of public defenders to effectively provide legal counsel. But these are real and possible effects that can really affect indigent defense systems as a whole. And we know from other studies that high rates of occupational stress among physicians, for instance, and teachers affect the well-being of patients and students and the quality of services that they receive. And the second implication, I guess, that I would bring up is that there are many other, I guess, occupations that work within the what Bourdieu and Lacan call the left hand of the state, who might similarly be dealing with the consequences of extreme inequality. And these occupations may also experience what we define as the stress of injustice. And then the final word is just a little bit about maybe a comment perhaps on what's happening with access to justice internationally. This is happening in one of the wealthiest countries in the world, where criminal justice system is very much in the news all the time. It's very much a focus of researchers across the social sciences, but access to justice is also a global problem. And I think it's a global problem because indigent defense systems, in whatever form they might be, are not really designed to keep up with the rate with which countries and entire regions rely on the carceral state to address social inequality and problems of extreme inequality, poverty, and as we've been seeing over the past few years, refugee and the migrant crisis that's been happening. So moving forward, I really hope we continue shedding light on the workers and institutions designed to protect the rights of people in poverty in the US and around the world. Thank you.
Thank you, Valerio, for the call for action, and also for sort of casting light on the workers, right, on the people doing the work and their clients. I think that was one of the things we wanted to do here. Also for pushing us to just not only think about Latin America, to think about things happening globally and to think about other domains of work. I know Ricardo Lillo, for example, had been thinking about civil courts and public defense in that civil context. In the US, we struggle with the provision of legal defense for immigrants in sort of immigration courts, something that is not happening in most of the country. So thank you for that. I now want to introduce Ligia Madeira. So good to have you here. Thank you for joining us. Ligia is a professor from the Federal University of Rio Grande do Sul. She has a MA and PhD in sociology from that university and has been working on comparative issues associated with legal institutions, but also human rights, development, and violence. Ligia, it's so great to have you here. Thank you for joining us.
Thank you. Let me try to share, but I don't know if I am doing it right. Well, when I need it, I will share just some tables and graphics. Well, good afternoon, everybody. It's a big pleasure to be here is so important to share knowledge about the public defenders in Latin America and in US. It's so interesting to compare the Brazilian case with other countries, because we have a state public defenders with a high level of institutionalization today, and we have a quite good data, I can see. And Ludmila called me to present a paper that I published some years ago about this process. We had a reform, and after that, we disseminate the public defender's office all around the country, and it's about this that I will talk a bit today. What can we say? The first signs of the public defender's office in Brazil appeared in the context of the military dictatorship, but it developed systematically only after the 1988 constitution, when democracy returned to Brazil and to other Latin American countries. And from this phase onwards, the public defender's office started being considered vital as a guarantor of rights and for ensuring access to justice. And Brazil is part of this model of bureaucratic system of public defense, in which state agencies and public attorneys provide legal services for poor people or indigent people or vulnerable people. And this model is characteristic of Latin American countries, where public defenders were structured in the 90s and inside the debate on judicial reform. But different of the most PDOs that are limited to the penal area, to the criminal defense, Brazil is a case where legal assistance is given to all the areas of law, like countries like Mexico, Panama, Uruguay, that present criminal and civil aid. And countries with federative structures such as Brazil, Argentina, and Mexico develop different legal structures for their federal and state courts, and Brazil is the same. Our state federal defenders are much more developed and independent than the federal case, but the federal case is an important case too, because at least in Northeast states, all the 60–70% of the judicialization of social rights in the federal justice is conducted by the federal, the DPO, the Public Defenders of the Union, the federal institution. Well, it's so important to study the Brazilian case, firstly because as a so unequal country, almost 90% of the population qualifies for free legal assistance in Brazil. Second, Brazil is the one few cases that has a constitutional mandate to provide public servants to provide legal assistance. And the public defenders is a young institution compared to prosecutors, to judiciary, and with a quite important political and social role. Well, in this paper, I will present the investigation about the institutionalization of the State Public Defender's Office before and after the judicial reform that granted independence and new functions to the Public Defender's Office in Brazil. The main objective is to see the capacity of coercion and diffusion of the judicial reform policy in terms of access to justice. This reform, created by the federal constitution with the aim of guaranteeing access to justice to the less privileged groups in Brazilian society, with the public provision of legal assistance, took over 2 decades to be implemented by the states in their institutions. And after a slow process of institutionalization, it underwent a great change with the enactment of Constitutional Amendment number 45 in 2004, which in the context of the reform of the judicial branch granted independence and new attributions to the Brazilian Public Defender's Office. The process of independence and autonomy of the Public Defender's Office in Brazil, achieved through constitutional and legislative changes, must be understood in terms of Brazilian transition to democracy, that I call, and this transition took place in a context of ample participation by actors and social movements, especially those of lawyers whose role in defending human rights was vital to establish public policy. The attainment of independence by the Public Defender's Office can therefore be seen as part of two larger movements, according to ideational theories and the perspectives of governance. In the ideational terms, the possibility of increasing access to justice is part of Latin American democratic political projects. All the pressure groups that contribute to this project, including national and international actors, like the National Association of Public Defenders and the International and Latin American Public Defenders Association, legislative boards and other boards of members of justice system, such as Association of State Prosecutor's Office, judges also participate, and a massive mobilization of civil society, like lawyers networks, the Catholic Church, the Prison Pastoral Commission. And from a governance point of view, the process of independence can also be understood in the context of a coordinating strategy by federal government, recurring in several other movements of formulation and implementation of public policies in Brazil. With them, the actions of the federal government in attempt to formulate policies that are executed by the subnational entities aim to reduce regional differences and inequalities. National legislations tend to give greater uniformity to institutional design, aiming at the creation of a simple performance standard. The executive branch showed its support for making the PDO autonomous by authoring the legislation aimed at reform. The almost unanimous vote in the Senate also showed the endorsement of the legislative branch, backed by the social and electoral appeal of expanding access to justice. Well, then, in terms of institutional independence, what can we see? We compare three periods, and in order to demonstrate the changes caused by the institutionalization of public defenders, the data present from the first period to 2004 covers the institution before the reform. Data from 2006 show the institutional transition, and the data from 2009 shows a stable institution 5 years after constitutional changes that guaranteed independence. We can see, in line with studies on the, well, we build an index in order to investigate a possible relationship between institutionalization and achievement of autonomy. We built two indicators. The first one regarding institutionalizations was created with variables time of creation, number of competitive civil service examinations held. And the second one regarding independence, from which we would be able to measure the independence of the PDO. We established a ranking system that computed the presence or absence of certain powers. The index consists of 2-point interval attributes to the presence or absence of each feature, making possible to see a greater degree of independence in states with high scores. It must be mentioned that the study analyzed the independence of exclusively de jure measures, not in real terms. And in line with studies on independence of the judicial institutions, our data on independence consider two largest areas, one regarding the institutional procedures that rule the institution, and other regarding the chief public defender's exercise of power. In the first dimension, there are variables aimed at verifying the presence of independence in legal terms, such as the existence of an organic law, a board of the Public Defender's Office, other variables focusing on the procedural exercise of independence, such as the selection of a chief public defender from a 3-candidate list. And finally, there are variables that indicate the actual exercise of independence, such as the availability of financial resource without subordination to state executive. The second dimension includes variables that indicate the amount of power in the hands of the chief public defender in terms of creating and abolishing posts, rank, discipline, and budget choice. Well, comparing 2004, 6, and 9. In 2004, 5 public defenders' offices had no independence, 12 had low independence, and 5 were considered independent. We saw that even before the reform, there was a trend on increasing powers in the institution, and the non-independent public defenders, the degree of interference in decisions were very high, without the possibility of the institution defining its job posts, and especially not its budget and wages. And the scenario was different in the independent institutions, although they were few in numbers and still had no significant prerogatives regarding wages and budgetary issues. Before the reform, there was great variation and independence of the chief public defender. The more the public defender's office became independent, the greater the power of the chief public defender, but his role was always limited in budgetary and wage issues. In 2006, the data showed very significant changes, with only 1 PDO remaining without independence. However, the number of PDO with low independence rose to 14 states, and the number of states with PDO considered independent rose to 9. This panorama drastically changed when the independent public defender's offices are compared with one another during the reform, as for the first time they saw an increase in the exercise of their autonomy, both in formal and procedural terms. In all states, an organic law and a higher council came into existence, with the choice of the chief of the institutions being made from a list of 3 candidates. The chief public defender's exercise of power also increased in practically all states, allowing him to create and abolish posts and to set and adjust wages in more than half the institutions. And after the reform, in that year, in 2009, the number of PDO with low independence fell to 13, and the number of PDO considered independence rose to 10. In comparative terms, if we compare the institutional degree of institutionalization with its degree of autonomy in 2004, 6, and 9, we see that there is no direct relation between the fact that the public defender's offices were institutionalized and their autonomy. What this analysis reveals, which corroborate a great part of the studies on judicial independence and some theoretical studies on the autonomy of state prosecutor's office, is that in despite of them having de jure independence by law, in fact, many state public defender's offices are not independent because autonomy means meeting prerequisites that which at the same time the states had not met. Although we see an evolving panorama that we can draw conclusions from the gap between what the law stipulates and what actually occurs. When we establish a comparison between the HDI in the states and their independence indicator, we can see a distribution that prior to the reform, there was no valid relationship between independence and HDI. And in spite of this, we were able to see that during the reform, there was a tendency of non-dependent states with a low HDI to remain so. They seemed incapable of establishing independent public defender's office. A comparison between periods showed a tendency towards an expansion of independence after the reform, including in states with a low HDI. However, the fact that states with a high HDI remain non-independent after the reform is worthy of attention, as it shows that, as well as socioeconomic criteria, cultural and political factors also interfere in the institutional trajectory of states. Well,
Ligia, just want to remind you, you're running out of time.
Okay, I just will finish. To update the scenario in terms of effects, we need to discuss to extend active informal independence result in the actual exercise of independence by the state PGOs. Today, we can see the coverage of the Public Defender's Office remain insufficient in Brazil, reaching only half of the judicial districts. There are significant regional disparity, although the effects of institutionalization are visible in the north and central western regions, with low coverage remaining in the southern and southeast regions. And the scenario is worst in the Federal Public Defender's Office. And to finalize, like other judicial and public security reforms carried out in Brazil, some states and regions with a low degree of institutionalization seem to respond better to the federal government's inducements in terms of public policy than the others, the more institutionalized states. Well, this is all. Thank you.
Thank you, Ligia, and I appreciate your perspective as someone who works in a political science department to think about reform and how change happens over time, what sticks and what doesn't, and how context matters. Thank you for that. Just want to remind people we have a chat, so if you want to type your question, we'll read a few of those questions at the end. We can do that at any point, add your questions to the chat. And now we're going to listen to our last presenter for the day. Thank you, Ulda, for being patient with us. Ulda is a PhD student in sociology at the Universidad Católica in Chile. He is also trained as a lawyer and worked in Paz Ciudadana, an NGO, before joining Universidad Católica. He's now a visiting scholar at Rutgers. Ulda, the floor is yours.
Thank you very much. Thank you, all the colleagues, your presentations were very, very interesting. So I want to share you a presentation. So I'm going to talk you about the specialized unit for prison defense implemented in Chile by the Public Defender Office. For this purpose, I will share with you part of the finding of a series of studies carried out by Justicia y Sociedad UC, who is my research center, a research and policy center in Universidad Católica de Chile, who has carried out more than 20 study focus specifically in prisons and more than 19 studies over 15 years in criminal justice. So I will begin with some background about indigent defense in Chile and the work of Defensoría Penal Pública, the public defense service. Unfortunately, Ricardo made some work for me at the beginning of this.
Ulda, can you put your slides on presentation mode, because it's looking very small at the moment?
Sorry. Yeah, can you see it?
It's small.
No, your presentation at presenter mode.
It is small. That's the problem.
Yeah.
Let me check. What could be?
Now we see something.
You're not seeing them. Okay. Sorry, I understand. Let me check. Why I can see the Zoom? Sorry, I can't see you. Ah, there it is. Okay, can you see it now?
No, we
No.
see a book.
Sorry, so sorry. Let me-
Antichrist.
We can just go back. Yes, exactly.
Yeah, now you can see it?
Just the
No, sorry. Let
just
me,
a small part of it.
yeah, give me a problem with my computer. Just a second, please.
And so while we fix this, so realize that the time is almost, I guess, 3 p.m. So people need to go. That's obviously okay. We're running a little bit behind, but after Ulda's presentation, we'll do
can you see it now?
Q&A. Yeah, this is better.
Andres?
Thank you. Yeah, go ahead.
Yeah, okay, go ahead. So, has Ricardo made a lot of work for me? I will go through this quickly. As you may know, in Chile, we have a constitutional mandate to provide defense in criminal cases. And for this purpose, 23 years ago, the Public Criminal Defender Office was created, no? Defensoría Penal Pública. Although it is under the supervision of the Ministry of Justice, the Public Criminal Defender Office enjoys high level of autonomy because in practice it has his own budget, for example, and the executive branch operation is limited to the election of the national defender and is almost non-existent in a day-to-day basis. As Ricardo tell us, the Public Criminal Defender Office have Turner defenders and Tenderen defenders and a general defense unit and a specialized unit. One of them is the you can call it in English the correctional defense specialized unit. So some topics about this special unit. It begins in 2009, has a pilot project in 2017 by an administrative resolutions. The service organized its functions and tasks at national level. And at this date, it's implemented in most, but not at all, prisons in Chile. They work in teams. The team is formed by a lawyer, social assistants, and an administrative assistants who basically make judicial representations requiring, for example, parole or other prison benefits or denouncing rights violations to the interns, making requirements to other state institutions to obtain mainly social benefits inside the prison, and making a general work of dissemination of rights, informing prison population of their rights. About how do they work? First, there's always a requirement. More than 16% of the requirement are made by their own inmates. Less than 20% is made by the unit. Then the process says that they have 20 days to make an initial interview with the applicant, and then there must be a response satisfying or not the requirement of the inmate. By 2018, the average response took by 17 days, and the mainly requirements, or the main requirement was parole, then transfer to another prisons, and then another series of requirements. The point here is that the requirements actually were very concentrated in judicial or legal requirements and less on social service requirements. They have actually 68 units, teams in around all the Chilean prisons, this number is not actualized for 2018. They are at least 26,000 of inmates. Today we have 14% more than the number of inmates, and they attend around 20% of the prison population of the correctional system in Chile. So all this take place in a context when recent research in Chile shows that the main needs of the population deprived of liberty are not so much related to access to legal benefits, but rather to non-legal social benefits. In that aspect, Chilean prisons are not so different from the rest of Latin American prisons, as many of you know, and for example, as Professor Fondevila is here with us, shows in his recent book, problems of habitability and overcrowding, lack of access to educational or social reinsertion programs, and the conflict that arise from the arbitrariness with which certain decisions are perceived to make inside the prisons are common in Latin American prisons. So in this context, we think that there are two possibilities, and that are only hypotheses that must be explored in further research in Chile or other Latin American contexts. Either the activity of the Correctional Defenders Unit has made it possible to satisfy the legal needs of a person deprived of liberty, but has not still been able to meet their social needs, or in other hand, its activity presents problems of targeting, and it's concentrated on satisfying problems that are not prevalent in the Chilean incarcerated population. To conclude, I want to offer you a look of some aspects that have limited the implementation of the prison defense of this specialized unit in Chile. First, for example, has in many other of our countries, the institutional culture of Chilean prison service. No? The prison officers perceive the work of prison defender as an intrusive activity, perceive that the inmates abuse of the exercise of their right, especially because they think that the right promotion exercise is contradictory to the idea of discipline and order. So basically, the defenders doesn't allow them to make well their job. In a second factor is the culture of the inmates, because as you know, many inmates distrust of state institution and prefers the use of informal or violent ways to resolve their conflicts. And in the case of those who want to go to this defense unit, are viewed as distrust by other inmates. But, and that's my last point, even the institutional culture of the public defender's office, it's been a problem for this program. Why? Because the correctional defense is perceived by the correctional defenders as a second level service. Why? Because they are not tenured, they are tendered, they have more workload, less salary, precarious work conditions, and also the not lawyer part of the team perceive themselves as invisible in the context of a institutional ethos that basically goes around the legal service provision. So that has been some of the problems of the specialized in the correctional defense unit that I want to share with you. Here is the reference of part of our work that profundize in this topic. So thank you very much.
Thank you, Ulda. It's very interesting work, and I hope we get to talk about it in the Q&A. So let's, I think we have about, and again, it's 3:05, we have about 10 minutes for questions, so people can stay here for that, and then we'll have the closing remarks by Gustavo after that. Apologize for us running late. There are a couple of questions in the chat, and I'm just going to try to go in order, if that's okay. Yeah. So, Ryan, you can read your question, or happy to read it if you're still here. I see you here. I'll just read it. So there are a couple of questions actually for Maria. So about the institutional structure of the PD system in Colombia, and then there's a question also from Maria-Fátima about war and sort of the role of the legal system and the reshaping of the legal system in Colombia. So that's maybe we'll start that. And then if anyone has another question after Maria speaks, then please add it to the chat. Thank you.
Okay, thank you for the questions and for the super stimulating presentations. Sorry that I have to leave in about 5 minutes, so it's great that I started with the questions, and I apologize. So regarding the first question, I will briefly say that there are only 3 types of profiles of people that can be public defenders in Colombia. The jurists or attorneys that are hired as public defenders by the Sistema Nacional de Defensoría Pública, like the national system of public defenders, the law graduates who complete who are completing the judicial training in the system, or their legal training in the system, and students who are being part of the legal clinics at their law schools. The system, the national system, is led or administrated by the Defensoría Pública, which would be like the ombuds person, and the selection of public defenders is undertaken by the system, which, as I mentioned in my presentation, evaluates candidates previously, like who have been previously registered in the National Registry of Public Defenders. So it is centralized, and it has like as I mentioned, a quite decent screening process that we don't have in terms of other legal professions. As for Maria-Fátima's question, it's tricky to answer because indeed we don't have too much information, but based on the empirical research that I have conducted in some regions in Colombia, what I would say is that yes, it affects not only the number, but the profile of the persons that could be or want to be public defenders, at least from 2 perspectives. So on the one hand, as I mentioned in my presentation, if you work in those like dangerous regions, or where the institutional capacity is very weak, then you don't have to comply, or you don't have to meet all the requirements that you would have to meet in central cities. So it would be good for you if you are, to put it that way, if you're underqualified. But at the same time, like, many people don't want to work in those regions, right? And that happens as well with judges. So what I think we should promote is a stronger system of incentives to make sure that we have highly qualified and interested and committed public defenders and judges in those regions where, like, high profile judges and attorneys regularly wouldn't want to go, right? So I think my main concern right now, and I think it has to be studied, and I hope we can keep discussing about this, is how to create or come up with better incentives to have better public defenders all around the country. Thank you.
Thank you, Maria. And I think the problem of staffing and recruiting and retaining public defenders is it's a huge problem also in the US, where obviously with that kind of support is very difficult to run a system. Okay, I invite any other questions at this point, maybe from our colleagues here in the US. If there's anyone who wants to speak, this would be a great time. Okay, we'll do one more final round of questions after Gustavo's presentation. Maria has to go, I know, and again, people may have commitments, of course. Let's have then Gustavo, and then we'll come back for one last round of questions. Gustavo.
Okay. Well, I want to start by thanking all the participants for their contribution and for making the time to be here today. Really, really thank you very much. To make concluding remarks from your panel is very difficult. So, well, I will focus on just 3 highlights that are relevant for future research, I think. The first one is big comparisons versus strategic comparisons. At the beginning of the joint work, I always thought that the only way to compare public defense systems in the region was to work on cross-cutting issues. For example, race, the racial bias of judicial systems in Brazil and in the United States. But after having heard, for example, the work of Fátima, the work of Ricardo, I think perhaps a more focused and minimalist strategy will be more productive. The role of the public defender in Sao Paulo is quite similar to the public defender roles in Mexico City and maybe in the south of the United States, but quite similar, but quite different to the role of a public defender in Argentina, in Buenos Aires. The second big issue is the indicator of public defense work. I believe that most of the scientific studies in the region, and I mean Latin America here, do not always incorporate the perspective of the public defender community itself. We have not been able to establish a good dialogue with the defense, with the public defense in Latin America. Measurements are based on comparisons with the work of private attorneys or client satisfaction or terminal efficiency or defender legal strategy and so on, but sometimes without fully assuming the bias of those type of indicators. I think public defenders are right in not feeling fully understood by criminal justice scholars here. And I think we need to turn the subject around to make maybe more complex indicator. And finally, a topic that has also been relatively neglected. Who are the public defenders? We don't know. We really don't know. What do we know about them? What kind of public role or public identity do they have? There is a big difference between a public defender in Mexico City and in Santiago de Chile, for example. Where did they study and what kind of judicial culture do they have? Here again, I perceive great difference between countries and judicial systems that maybe allow us to break away from the global north and the global south paradigm in this issue, the public defense. Okay, to close this panel, I hope I have done justice to your works, and once again, thank you everyone for taking time to discuss these topics today with us. Thank you very much.
Thank you, Gustavo. That sounds like an agenda for our next meeting or for a future meeting.
I hope so.
Thank you. I want to just open it up again. I know Ryan had kind of a big question. Maybe panelists who are still here can reflect on that. What work is being done to advocate for a, I guess, more independent system or a more true independent system, if that's something that can be done. Are there any other questions before we do one quick round of final thoughts? Ulda?
Yeah, thank you, Andres. I have a question specifically for Maria Ceballos, but it could be also a question for another of especially the Latin American colleagues. In Colombia and in Chile, we have social ombuds, estallidos sociales, recently in 2019, 2020, 2022. I remember was the years. And in Chile, we saw how defendants gave up the public defense because they consider it is low, it doesn't represent their interest. That's they feel. I could conduct a research when we could document that that kind of things. And they hired private lawyers who in Chile are generally of lesser quality, but who provide them to understand their political motivations and say him that they could help them better. But finally, there was worse for their defense or their interest. So my question is if something similar has happened in Colombia. It could be in the context of your social orbus, of if you have general information about the reasons for people to choose private defense instead public defenders.
Thank you. All right. Thank you for that. Okay, well, let's have our presenters have the last round of comments. I'm sorry for press us all for time, but you know, that's what we have to do to be mindful of people's agenda on a Friday. Thank you. So whoever wants to go first, please, Maria.
Yeah, just a short reply because I actually don't have data on that, but I will give you like my intuition of what happened during the outbursts, which was that many people were represented in courts by law professors. Because there are like, especially law professors from public universities are really committed to like defending vulnerable populations and social and economic rights. So that's what I could witness. But I don't think they got paid. They were like public, unofficial defenders, which is something like a very interesting phenomenon to study, but that's all I know. But thank you for the question, and I look forward to exploring it, like ideally with you guys.
Thank you.
Any concluding thoughts? Ludmila, also Miguel, people who were involved in presenting, other presenters.
Just to thank all the presenters for sharing their knowledge with us. And maybe we can continue this conversation in another forum or another seminar, or maybe we can even organize a special issue in a journal related to the subjects that we have discussed here.
Thank you, Ludmila. I appreciate everyone. Thank you for joining us. Torin, I think you're our co-host at Hydra now. Thank you for staying with us past the time and for, again, for providing this venue for us to talk.
Thank you all very much.
Thank you all.
Bye.
Thank you all. Have a nice weekend.
Thank you.
Thank you very much for your note.
Thank you.